I'm pleased this morning to have an opportunity to introduce an illustrious panel of experts here in the state of Michigan that have a lot of information that I believe would really be helpful to you as business owners to understand how legislation can impact your business. And obviously most business people do not have an opportunity to get to Lansing and learn what's going on in real time or what's coming up that really can negatively impact your business. So I've invited a great panel here this morning to address some of those issues. And we have first from the Michigan Chamber of Commerce, Wendy Block, from the National Federation of Independent Businesses, Amanda Fisher, and from the Michigan Retailers Association, Amy Drumm. And these individuals have some information that really is important for you to understand, digest, and really stay involved with, because what happens in Lansing legislatively really does impact your business. And with that, I would like to turn it over to Wendy to begin the discussion.
Sure. Thank you, Senator, and we appreciate the invitation to be here today and appreciate the ongoing relationship with you and your team in terms of just your work here in Lansing. So this morning we're going to talk about a number of items that are coming in the legislature, or things that we think are coming, but we're going to start with a summary of the first 6 months of the 107th legislative session. So we'll talk about a little bit about what's happened, what might be coming, and then we'll talk about, end with a discussion about the minimum wage and paid sick leave issue, because those things are outstanding still in Lansing and have significant impact to Michigan's business community. So as the 102nd legislature convened, there was a lot of discussion, especially because we're in this new time in Lansing with Democrats controlling the House and Senate for the first time in over 40 years. And so we heard a lot of calls for things like bipartisanship and finding common ground and ending political stalemates and partisan bickering. We're now in, I think, week 18 of this legislative session, and we're kind of seeing some of those things maybe not play out quite as had been discussed, but in other ways I think we are seeing that people are starting to have good conversations about public policy. So when the House and Senate Democrats first took office, they led with 6 key priorities. All of these things have now been passed, so that is somewhat of note, but a number of these things we feel are significant for Michigan businesses and will have some negative impacts moving forward. So those 6 things were repealing the public sector tax on pensions, repealing the 1931 abortion law, increasing the earned income tax credit from 6% to 30% of the federal credit, expanding the Elliott-Larsen Civil Rights Act to the LGBTQ plus community, and then most notably repealing our right to work law and restoring Michigan's prevailing wage law. So right to work is about the freedom of individual workers to decide whether or not they wish to join a union and use their hard-earned dollars to support those activities. And prevailing wage means that we are returning to the days where union scale wages have to be paid on public construction projects regardless of whether a union is used for that work. So as I mentioned, all of these things at this point have been signed into law. There's just a question of when they will take effect, something that we call immediate effect. It has been an issue. So the bills did not get sufficient votes, which is 2/3 votes for immediate effect. So what that means is that the bills will take effect in accordance with the constitutional provisions that say that no act shall take effect until the expiration of 90 days from the end of a session at which the bill was enacted. So normally the legislature will adjourn for the year at the end of the year, so in December. So if they adjourned in December of 2023 like they normally would, that would mean that those bills, those 6 bills and anything else that gets passed this session that doesn't get immediate effect would take effect in March of 2024. But there is, I think, a desire on the part of several lawmakers to speed up the effective date for these bills because they didn't get immediate effect. And so there is some discussion in Lansing about the legislature adjourning early, something we call sine die. So the bills will take effect 90 days after the end of that date. So if they adjourn, say on July 1, that means that those bills could actually take effect on September 29 of this year, assuming that July 1 date. And so that is key because employers will have to comply with those 6 priorities that we talked about or any other bills that have passed that don't have a specific effective date, and really could speed up the date by which employers need to comply with those laws. So from here, we're going to talk a little bit just about kind of some of the things that we think are coming on the horizon. And I'm going to hand things over to Amanda Fisher from NFIB to talk about a number of labor policies.
Great, thanks, Wendy. And I also want to say, while we're trying to work with our friends, the Democrats, especially NFIB, we tend to be more focused on making sure that we're not implementing a lot of these policies because our members want us to be a little more far to the right. And I want to thank Republicans for standing up and really standing firm and making Democrats come up with the votes on a lot of these things. So I feel like I need to say that because a lot of people are saying, oh, well, what are Republicans doing to stop this? Well, they're doing everything they can. And so we have some of the next level labor bills, which really involve kind of nibbling around the edges of some of the union issues. So allowing union dues to be automatically deducted from payroll, allowing contributions, political contributions to unions to be deducted from payroll. A lot of these things were ways we nibbled around the edges before Right to Work passed in 2012. So we're very much excited about, we're not excited at all about these. But ultimately with Right to Work being lost, it's going to be a challenge to keep a lot of these things from kind of spiraling. I think another one that we weren't involved in was allowing grad students to unionize in the universities. So some of those little bills, but they're going to start adding up. You also have refundable tax credits for union dues. And so we always say here at NFIB, and I know a lot of the trade groups, how about refundable credits to belong to an association that's representing you? It's really no different. So another one is local preemption. We did a lot of preemption bills in the 2010 or 2011 to 2018. And those bills basically would preempt locals from either prohibiting things like plastic bags. There are some local governments that wanted to say, no, you can't have plastic bags in our county, in our city, or passing minimum wage laws, mandated paid leave, predictive scheduling, and those are things that we prevented the locals from doing that folks would like to roll back. And I know Amy can comment a little bit more about how troubling preemption is, especially plastic bags with retailers.
Yeah, thanks, Amanda. So the preemption laws that we worked on, the reason we did these was because we looked at these issues as being things that really should be best handled at the state level, that we did not feel that these were issues that locals needed to be involved in, and it created a patchwork of requirements for businesses to follow that make it much more difficult if you've got more than one location to know which rules you follow where, which standards you follow. They may be conflicting. And so again, we thought these are best handled at the state level if they're handled at all. We certainly prefer that business owners be allowed to create their own standards and their own pay requirements and determine what types of products you can take out in what ways, whether it's a bag or a styrofoam container or whatever it may be, to protect your items and get them home. And so we had a lot of concerns with these. We worked to passed these laws because, again, we thought we wanted to have some clarity around what could happen. We saw what was happening in other states and other jurisdictions around the country. We didn't want that to happen here. And so the concern is that they would look to repeal those laws. There are bills introduced in both chambers that have a lot of support from the majority party to remove the preemption and allow locals this control again, which we think is inappropriate. So there are a lot of concerns there. We are working to make sure that we can keep those on the books, hopefully, but it's certainly something we're watching closely.
Yeah, and again, the patchwork of regulations is a really big issue, especially for small business owners. If you have one or two, like a franchisee has one or two spots, so you've got something in Lansing and something in St. John's, and you have completely different regulations you have to follow. That's a really big deal, especially for your smaller businesses who don't have the same HR capacity. And it's a big deal for big businesses too, because it's a headache and it costs more to comply with those regulations. And ultimately that goes to the consumer. All of this gets passed down to the consumer, whether it's directly or indirectly. A really concerning package of bills that was introduced and had a really quick hearing a few weeks ago was on it was a variety of bills. The biggest one was an independent contractor bill, and a lot of people think independent contractors have to do with construction, but independent contractors are actually 1099 employees, so they're people that aren't employees but are doing work for you. And so this bill is based on what California did, and a lot of people may have heard about the California issue because it was such a big deal, that basically essentially eliminated independent contractors. And the reason this is an issue is there are folks that say that businesses use independent contractors somewhat illegally, and it prevents an employer from having to pay unemployment insurance, having to pay their the employer taxes, those sorts of things. And there is a standard here in Michigan. There's a standard, there's a federal standard, there's a standard in Michigan, so it's not like it's carte blanche. But this would so severely limit independent contractors, it would get rid of them. So you wouldn't have the gig economy, so your Uber and Lyft, your Shipt delivery, your Grubhub, they would all have to be employees. Independent truck drivers would no longer be able to function. A lot of consulting firms with business-to-business transactions, construction definitely, and it's so bad in California that there are actually, I think, 109 exemptions, including Uber and Lyft and construction and trucking and all of these issues. So in fact, there are things we didn't even think of, like actually language services. So the folks that provide translators in like a hospital, if somebody needs a translator, or if we have somebody who's hearing impaired and they need sign language, all of those are independent contractors. They would no longer basically exist in Michigan because they don't want to be employees, and they would be required to be employees, and a lot of the employers hospital wouldn't be able to keep all of those folks on staff. So it's a really big issue, could have far-reaching effects on a lot more people than probably people even realize. And so we're very concerned about that and that issue. There was one hearing, and Wendy and I both testified on that. Wendy got the brunt of the fun in committee. If you want to check that out and go to the House Labor Committee, you can watch it on demand. And so that is a really big issue. There are other bills in the package. A lot of these bills increase employer penalties, making things that are currently a misdemeanor a felony, taking $1,000, right now a max $1,000 fine to a max $10,000 fine. which are pretty significant increase, would change some significant laws. For instance, whistleblower protection. An employee would be defined as a prospective employee or an independent contractor, so not just somebody that's working for you. And if they thought that you were going to break the law, or did break the law, they could turn you in, and then they would actually get a 30% cut of anything the state recovered in fines and penalties. You also have another bill that would require an employer to disclose what other employees of the same seniority, same job, kind of what they're making. So that could create a lot of problems, not just for the employer, but also for the other employees who their salaries are being disclosed. And this is all done under the guise of people are being discriminated against, and so they're not making the same salaries, and they should be able to deal with that. So those are some of those bills. Also eliminating non-compete agreements, and also allowing private individuals to sue on behalf of the state. And I think we all know a lot of those private individuals would end up being trial attorneys. So that's basically that package. There's a lot in there. And I'm going to turn it over to Amy to talk about predictive scheduling.
Yeah, so another bill that we're watching closely has to do with predictive scheduling. We would actually refer to it as restrictive scheduling because we know employees typically want flexibility. This bill that was introduced, is the most aggressive bill we've seen in the country. It would apply to retail workers, which includes auto workers. So auto workers at car dealerships would be impacted by this as well. So again, think of a very broad definition of retail. It includes food service workers, so restaurant workers, bar workers, and then hospitality, which extends to entities like spas and others, not just hotels and motels. And it would apply to anybody who has 100 or more workers in the state as an average number of workers over the kind of a 20-week period from the previous year. And what's scary about this is they want to require a 14-day in advance schedule that's put out. So you cannot make any changes to the schedule for 14 days before the date that you would start working. And then if you do make any changes, regardless of whether the employee makes that change and you have to, fill that spot, or if you as the employer try to make a change based on how busy you are or whatever may be going on, weather issue, there are no exemptions in the bill for anything like that. You would then have to compensate the employee for either reducing their hours or asking them to work more hours. So you are being penalized for having any changes you make. You would have a set 14-day schedule. If you make any changes at all, you would be penalized. Now, they try to add in this voluntary list, standby list you can be on. It requires somebody to provide a written signature to be on the list, to add in. There's really no incentive for them to do that because they're going to miss out on that added bonus pay, essentially, if their schedule were changed. So you make it more hours, but you're not going to get the added pay. So your coworker who's not on the list, who gets called into work, is going to get paid 1.5 times more than you, and that doesn't make sense. So we know, there's a lot of flexibility that a lot of these workers want. This typically isn't their only job. They may be also going to school, maybe juggling something else, picking up extra hours, and they like the flexibility that these types of work typically provide. And while employers today are already trying to be as flexible as they can and provide schedules typically a week or two in advance, but allowing changes to happen, this would not really work under that law. And then something that's worth noting is it also would include a 7-year record-keeping requirement. So imagine every schedule change, every schedule you put out, that's a lot of paperwork, that's a lot of documentation of getting people to sign an agreement that they're willing to work these hours, or when you put out hours, you have to promote it to every single worker. You would have to keep all those records for 7 years, and that is a ton of record keeping. So we have a lot of concerns about that proposed package. That bill's in the House. It hasn't seen any movement yet, and we're having a lot of conversations about the concerns we have and sharing those with folks. And so we're waiting to see if that's going to get an actual hearing at some point in the future here, but it's one that we are very concerned about because it would make all of those jobs and all those employers' lives very difficult to comply with something like this. So, and on the kind of the preemption guide, do you want to talk about stricter than federal, Amanda?
Yeah, well, I can, although I think
I'm gonna
that.
defer to Wendy.
I think that Amy, okay. So, again, I think a lot of these bills, even if they sound sometimes innocuous, the regulatory burden that is in them is really, really rough. And a lot of these bills also, the ones I mentioned before, include a cause of action against the employer. So again, the employer is now potentially could get sued in addition to fines and penalties from the state. So a bill was passed in 2018, actually it was passed in 2011, and Governor Snyder vetoed it. And then it was changed that would basically say, if you want to pass a regulation, if one of the departments wants to pass a regulation that would be stricter than what the federal law says, then they have to kind of write something up that proves why they have to do it. Obviously, there are times where that's necessary. We have the Great Lakes, so we have more concerns about some water issues and things like that, that it's appropriate that maybe we do have some regulations that are stricter than feds. But basically, the way the bill was written was just kind of an extra check with the department, because there's not a lot of oversight once the departments are given rulemaking authority. There's not a lot the legislature can do besides passing a bill preventing them from doing it. And so, however, this was voted on in the Senate, and we'll go over to the House to repeal that, even that one little bit of transparency. And so once again, you're taking another step forward of bureaucrats basically making laws and taking over the job that the legislature should have. And I'll also mention, when you're talking about regulations, there's a climate change energy package in the Senate. And this would basically say by 2035, we have to go to all renewable energy sources. So we get rid of, as our main focus, so we get rid of fossil fuels and such. And it would also require then the Department of Licensing and Regulation to promulgate rules that would follow the Healthy Climate Plan. And what's hidden in that Healthy Climate Plan is no gas appliances in new builds, whether it's commercial or residential. And would also require any new buildings to be built using all renewable energy, which would, the cost of housing would skyrocket, and we're already kind of in a housing crunch right now. So, but what's terrifying is all of that could happen without the legislature ever taking a vote. No one would ever have to vote on, prohibiting gas appliances, because it would be done by the department. So some of these regulations, these hidden regulations are really scary. And I'll turn it over to Wendy to talk about unemployment insurance.
Yeah. Okay, so we think that there's probably likely to be a number of changes put on the table related to unemployment insurance. And what's important to know about unemployment insurance is that it's 100% employer finance system. So employers pay for the system through payroll taxes on their employees. And given the high number of claims that were paid out during COVID, Michigan's Unemployment Trust Fund is not really, it's solvent, but it's barely solvent. So we should have somewhere north of $3.5 billion in the fund. We have about $1.8 billion currently. And there's a Senate bill out there to increase the number of weeks that people are eligible for state unemployment claims, to increase it from 20 to 26 weeks. But we expect a number of bills also to be introduced this fall to increase the weekly benefit amount which currently is $362 a week, to what they're looking at going to, we're not sure yet. Some states go as high as $1,000 a week, so that would be extremely troublesome just in terms of how quickly that would draw down the balance of the trust fund, and to increase the dependent allowance and do some other things. So this is something that could be a direct cost increase on Michigan employers, could force payroll taxes to go higher, so employers, there's money in that trust fund to pay the benefits that have been promised via legislation. So this will be something that the business community is united on, and working to make sure that those costs stay affordable for employers, but that people certainly have that safety net when and if they need to draw unemployment benefits in the case that they become unemployed due to no fault of their own. Amy's going to talk about the Family Optimal Leave Coverage Act, which is really like paid family leave.
Yeah, so this is a similar system proposed that would look somewhat like unemployment insurance, where the employer would be paying a portion of family optimal leave. And I think Amanda and I will tag team on this one.
Okay, yeah.
Because I think she's ready to talk about this too. But the concern with this is a very generous system. It creates an unemployment style system for paid leave benefits. It's very open-ended on how you can take the leave, who you can take the leave for, what you could use the leave for. The state would be running the program, and so you'd be applying to the state to get your benefits paid out from them, but the employer would be paying into the system. And one of the really concerning parts is that it doesn't have an end. We don't know how much it would cost. It gives open-ended authority to the department to set the rates that you'd be paying into the system. And if the legislature did not fund enough people to run it, and think of the unemployment system and how many people you have in the department looking at claims and looking at benefits and answering calls and questions, you would have the same thing going on with this program as well. So Amanda, what do you want to add to that? Concerns.
I'll add, there are a couple other concerns even beyond money. This would be like family medical leave at the federal level, except it would start any employer. So if you have one employee, whereas FMLA at the federal level you have to be over 50 employees. And it allows actually 15 weeks. And so what happens is somebody can take 15 weeks of leave, and not only is it paid, which is a huge concern that Amy addressed, but also you cannot permanently fill that position. You have to give that job back to that person. And if you're a small business owner who has like 3 employees, how can you cover for that employee for 15 weeks? And it's very broad how it can be used. It's for if you're family, if you have people that are affinity like family. So Wendy is my sister, and she's like a sister to me. So I'm going to take that time off to spend with her. And I understand there is some of that, right? When we put that in legislation, it makes it difficult. It would allow for military families, if they've come back from combat, they can use that time. And again, I think the problem is all of these are not, we're not trying to be mean and say, oh, we don't want this. But the problem is when you mandate this, you hamstring business owners, you hamstring and the employees. And honestly, my members who have 10 employees or less are going to try and help their employees out, especially their longtime employees, and do what they can. But when the government mandates it, it really limits how they can help and what the employee is allowed to do. There's so much trouble with this Family Optimal Leave Act. It's been introduced in the House and Senate. I have not heard any movement on it yet. But we're always ready because we never know when something's going to pop up. And I also want to say, because I think my time will be coming to an end, how much I appreciate working with the business community. You guys don't see what happens in Lansing, but all of our associations really work together so that we're able to be more effective for all of our members. And because all of us couldn't fight all of these things on our own because there are so many of them. So I'm going to turn it back over to Amy to talk about bad faith insurance claims.
Thanks, Amanda. One thing I want to add on the Family Optimal Leave Act too is that even if you have your own paid leave policy today, you would have to apply for a waiver from the department and meet all of the standards under this new proposed act. And then when you apply for the waiver and the exemption to do your own plan that you already have, you have to pay for the review of that plan that they will do. And they have to grant it. And then it could be denied later, and you'd have to go through the state system. So again, we're getting into things that are telling businesses how exactly you do this, that your plan isn't good enough, that really no matter what you do, you're going to be complying with some state requirement here, regardless of what you do today. And that is part of our concern with a lot of these proposals, is that they start from kind of this model legislation that we've seen in other states that frankly has been worked down and negotiated through, and we are back at kind of that original starting point, and it's starting here in that guise. And so we've got a lot of work to do if these were to start moving to get them to a point where they would be even remotely reasonable for business to comply with.
And it should be noted, we have a paid leave mandate in Michigan for those that are 50 employees or more. So it's not like we don't have these things in Michigan already.
Yeah, and a lot of employers do offer these benefits, but they offer something that they can afford. And our point on a lot of these legislative items is that, you know, one by one, they may sound reasonable, or they may sound like things that people want or benefits that they need, and our employers are trying to offer these items, but they can't offer every single last one. And if every bill passed, we would have so many new added costs and regulations that employers would have a really tough time meeting those and staying in business. And one of the things that we're watching, you know, this isn't a direct business related issue like we've been talking about, these HR issues and employment issues, but with insurance claims, you know, every business has to have insurance. Every individual in the state has to have insurance, whether that's homeowners or auto or life insurance or commercial policies. This proposed legislation that's being referred to as bad faith insurance would require insurance companies to essentially pay out insurance claims and assume that the claim is legitimate on its face, and make it very, very difficult for somebody that is an insurance company to deny that claim or ask questions. And this is going to lead to a lot of fraud and a lot of frivolous lawsuits on behalf of folks who want their claims paid quickly, because it says if you were to go through any hoops and deny somebody or ask questions, if you don't assume that their claim is legitimate, you are now going to be subject to a lot of fines and penalties, paying their legal fees. You'll be subject to penalties for denying the claim or asking questions if you change it. So again, these things sound like they could be reasonable if you want your claim paid and you were a legitimate person with a legitimate claim. We know that there would be a lot of illegitimate claims filed because the system would be so difficult to weed through those bad claims now, given the changes under this proposed law. And what we've seen in other states where they've done this is that the insurance claims and costs have grown dramatically. In Washington, costs for insurance went up by 20%. Premiums in California went up 32 to 53%. And so even if you're not the person who's filing the claim that you're going to get your claim paid quickly now, your issue is your insurance premium and your cost to be insured is going to go sky high very quickly. And so you're going to be paying for all these fraudulent claims that then can't be, you know, correctly assessed and corrected in the future because there's no real way to get through that new regulatory nightmare that you're going to be thrown into. And so these are things that are, you know, again, not maybe a direct impact, but they will have an impact on your business and the cost to run your business because you will still have to have insurance. And the cost will now be higher under this proposed law if it were to move. And so these are, again, we've talked about things being potentially death by 1,000 cuts or concerns of all these small policies and how they add up in terms of the cost added to the employer. So I know that Wendy mentioned at the beginning we were going to talk about kind of an outstanding issue on minimum wage and paid sick leave, and I will turn it back over to her.
Okay, so this is our last update of the morning. So there's some ongoing litigation related to minimum wage and paid sick leave. So in 2018, these two issues qualified for the ballot in Michigan. And under the Michigan Constitution, When an issue qualifies for the ballot, the legislature has an option in terms of how they want to proceed. So the Constitution says the legislature can do nothing once something has been deemed eligible for the ballot, and that means it just goes to the ballot. They can reject it outright, and it also means that it goes to the ballot. But it also allows them to put a competing proposal on the table, or they can accept it, and then subsequently they're allowed to amend that law with a simple majority vote. Unlike if the voters approve something, it requires a supermajority vote. So back in 2018, when these two issues qualified for the ballot, the legislature decided that they felt that the policies were needed some additional work. The people that had put these together, it seemed they had kind of done it in haste and hadn't really thought through the real world implications. So the legislature voted to approve these two ballot proposals, making them law, but indicated that they intended to subsequently amend those proposals, which they did later that year. So it didn't go, these things were never approved by the voters. They just were adopted by the legislature and subsequently amended. Since that time, there's been a challenge to the constitutionality of what is now referred to as adopt and amend, the situation where the legislature adopted a ballot proposal and subsequently amended it. In July of last year, the Court of Claims ruled that the legislature lacked constitutional authority to adopt and amend, but in January of this year, the legislature, the Michigan Court of Appeals, by a 3-0 decision, overturned that lower court decision, finding that the Michigan legislature did have the constitutional authority to do what they did, which we agree that they do, that the Constitution doesn't say they can't, and the Constitution actually gives the legislature plenary authority, basically meaning if the Constitution doesn't say that they can't, it's assumed that they can. And so we are now so the status of these laws has remained the same. The ballot proposal language has never gone into effect. That remains the case today. Michigan has a 10.75 minimum wage, and we have a paid sick leave law that applies to employers with 50 or more employees. So this case is currently on appeal at the Michigan Supreme Court. Our three groups and some others in the business community have been briefing this case as it's gone through the process. And we are waiting to hear whether or not the Michigan Supreme Court will take this case, and we expect them to do so later this summer, possibly before they adjourn on July 31st. So really, there's a lot at stake with this decision, and we're kind of waiting to hear what the court will do, if they will even take the case. But if the court, the Michigan Supreme Court, overturns the Court of Appeals decision, there will be significant changes that employers will need to make. First of all, it will require a $13.03 an hour minimum wage in 2023. The tip credit, the credit that employers use who have tipped employees, which basically guarantees that a tipped employee makes the full minimum wage when you combine their tips with the tip minimum wage. That tip credit will move from 38% of the full minimum wage to $11.73 an hour in 2023, moving towards a full minimum wage in the next several years. As it relates to the paid sick leave proponent, this means that all employees will be eligible for paid sick leave under the law. So even if an employer is already offering PTO today, it would force most employers to have to make significant changes to their policies. It certainly will apply to or require employers that have less than 50 employees to make significant changes to their benefit structures. There are no exemptions, so it applies to all employees, regardless of who they are and what they do. So think seasonal employees, part-time employees, others who are currently exempt from the law. And it increases the number of hours that someone's eligible for paid sick leave to 72 hours a year. What really is kind of striking about this policy is that it allows for intermittent leave, so someone could take their leave in as little increments as someone as you use to track payroll. So for some companies, that could be in as little as 6-minute increments. It does not allow for employers to have notification requirements. The employee just has to require notice or give notice as soon as practicable. And it has a rebuttable presumption whereby if an employer takes some sort of disciplinary action against an employee, it's assumed that you are retaliating against them for using their sick time, not because of other things, and it's on the employer to prove otherwise. And with the minimum wage, basically this creates a new floor, right? Most employers are paying above that $13.03 an hour, but not for all employees. Think about students or other people that you're just maybe trying to take in on a probationary period. So this pushes up all wages from that now new floor, and certainly will create somewhat of a tailspin for our restaurant industry, because it will be 156% increase in labor costs overnight for them, and they're going to have to figure out how to adjust. So kind of stay tuned on this one. We know a lot of employers and businesses are closely monitoring this issue. We don't feel like we really can guess what's going to happen, because you never know with the courts. And it's really outside of our control beyond the opportunity to brief in these cases. But that ends our update, and we appreciate the invite.
Well, thank you, panelists. I was really impressed with the amount of information that was dispensed. There's a number of things, I'm not on every committee, so there's a number of things that I was not aware of that are absolutely horrifying. And I think every business out there in the state of Michigan has to really think about not just, I think we're the only state that reversed right to work, which really on a national level, companies pay attention to that in deciding where to move. But all of these other initiatives and bills that would negatively impact business. We have one of the older populations here in the state of Michigan. We also have, it's either the first or second highest number of people leaving the state of Michigan. Currently, and with all of these devastating anti-business laws that could be passed, it's going to be very difficult for business to be able to thrive and survive here in Michigan. So what I would do is urge you to really get in touch with your legislatures, these different organizations, the Michigan Chamber of Commerce, National Federation of Independent Business, and Michigan Retailers Association. All will be more than happy to further go through the impact on your business individually. But as you can see, if all this stuff passes, we will be Michiganifornia without the weather. So it's going to be absolutely devastating if we don't really work together to turn this around. With that, I would like to thank my guests, Wendy Block, Amanda Fisher, and Amy Drumm, for being with us here today. And please feel free to get in touch with my office or any of their offices for additional information. Thank you.